can't ask you questions again, because you wanted to ask them initially.
Yeah.
5, 4, 3, 2, 1.
Welcome back, guys, and sorry for the interruption. A little bit of technical difficulties. Yes, we are in a technological age, but we do face technological difficulties from time to time. So thank you guys for waiting it out with us and remaining on the line. We have one more question for this session, and that question is for Ms. Smith. And the question is, or the question was asked, and you were in the middle of explaining whether changes can be made to a will. And so I am going to put that question to you again, because I don't now remember where you got to in responding.
Thanks, Madam Chair. I will go back to briefly summarize my answer. You can make as many changes to your will as you would like to. There is no limitation on the number of changes you can make to your will. However, those changes must be in writing, and the ultimate result has to be that you basically have a revised will. So the previous will, the last will that you would have done would have to, in essence, be revoked by a new will that incorporates those changes. So as I said previously, you cannot, by word of mouth, change your will. That would not be legally enforceable. Must be in writing, and the will has to be signed, as my colleagues would have said, must be signed by the person making the will and 2 witnesses. So the same formalities apply. You're basically doing over your will. But if you want to change your will every day, every other day, every month, or like some persons have done every time somebody pisses you off, you can change your will. But it must be in writing, and it must have the formalities that is required by the Wills Act.
Thank you very much, Ms. Smith. And now, we've now come to the end of the question answer section. Well, we haven't quite gotten there yet, because I do have a follow-up question for you, Ms. Smith. Thank you for whispering it to me. We wanted some scenarios where a will needed to be updated, was not updated, and the consequence, the unfortunate consequence of not updating the will.
The most important scenario that I can tell everyone, and it's not known, all lawyers should know, but the most important one is that you make a will, it's finalized, you may have registered it with the court, or you may have tucked it away in your safe or in your lawyer's safe, and then you get married after making that will. That will is no longer valid. If you marry after making a will, that will is no longer valid. So say you're married and you go and you try to enforce a will that was prepared prior to your marriage. That will is no longer enforceable. That person's wishes are gone. Second scenario, say for example, you made a will and you left a piece of property to your son. Unknown to your executor, your son, or anyone, you sold that property during your lifetime. You die. Your son is anxiously awaiting his property and wants to cash in on his entitlement. You have sold that will during your lifetime. Sold that property. It's no longer available. And you did not update your will, so your son has to be informed that that property was sold and you cannot obtain that entitlement because you parted with it during your lifetime. But you did not update your will to possibly remove that from your will. So you have a son who will be very disappointed because you did not update your will. So those are two scenarios that I would say highlight the importance of you needing to update your will.
Thank you very much. I think now we have gotten to the point where we can ask questions or take questions from the audience. And we have a mic moving, floating in the room for you to ask questions of the panelists, not me. I have my own questions if no one volunteers to ask them for me. So we see the mic has been passed to one person. Could you please ask your question?
Grand Rise, everyone. My name is Rosita Scatliff Thompson. I actually have two questions. First questions, I'm not quite sure you're aware that sometimes there's a standardized format wills that can be achieved online. My question is, if a person by chance filled that out and has that existing, and then move back to the BVI, let's say myself as a perfect example, does that make it still valid? Or to make it valid, I would have to actually have it notarized locally for it to be valid? That's my first question.
Yeah, okay, well, yes, well, the answer to that question is, it doesn't matter where you sign the will, if it complies with the BVI formalities, it's a valid will. And you have the capacity and so on, it's a valid will. So where you signed it, you don't need to re-register it or re-execute it once you come back home. The question is whether first when you sign it, whether it is valid or not, under BVI law. So if it's valid under BVI law, you don't need to do anything with it.
Even, sir, if it wasn't done with an actual lawyer, it's one of those easy, standardized wills that you can get access to.
No, but if it's printed on paper, and you sign it, and the witnesses signed it, and it's all on paper, you can bring it. The problem you may have is an inconvenience, really, because the witnesses may be where you were. So if you die in the BVI, nobody may be able to find the witnesses. So it's good to have witnesses in your locality.
Okay, so to bring it up to date, something like that, I would have to actually visit another local lawyer.
Yeah, and have it redone, update it at the same time.
Okay, thank you.
Yeah.
And visiting a local lawyer, I should add, what that would do is, it would also let you check with the lawyer that
Yeah.
you have complied with BVI law in the making of that
In the
will.
first will, anyhow, yeah. Yeah.
Morning.
Morning.
I think I have like a 2-in-1 question and then another question. So that sounds like 3. So I just wanted to know, like, from the younger generation perspective, would you say there's an age range or time frame that we should start putting together a will or start thinking in that direction? Because to be real honest, that don't really be of importance until like we get older. So I just asking. And also how we could make a topic like this more appealing to young people. Like for them to start even thinking in that frame of mind from a younger age rather than waiting until we get older and then so much going on now we ain't really like level-headed to think properly. That's my 2 questions.
Well, my 2 cents, I know my other colleagues are eager to answer that, but my 2 cents are, firstly, a will kicks in after you die. And the first reality of life is death. We're all gonna die. And none of us can dictate when. So we have a stigma that wills are for older persons, or to be made by older persons. But first thing I would say to young people, look around, look how many persons your age or younger are passing. So that in itself tells you that there's no timeline. The minute you accumulate assets, or the minute you have assets, you want to put your will together. Because if you piggyback on what we said earlier, you can change it anytime. So even if you make your will at 18, you may live to 78, 88, 98, you can change it as you go along, but at least you would have had your will in place from the minute you accumulate some form of asset to make provision for how you want that asset to be distributed. So my simple answer is the greatest reality of life is death, and you shouldn't only prepare for it because you're thinking you only die when you get older. You die at any age, all right? How do you familiarize the younger generation? I think with this generation, we're just gonna have to use the platforms that are appealing to them. And reach out to them in those formats. You're not gonna get the average young person, and I commend you for coming here, but you're not gonna get the average young person to come and sit down here like this. But maybe if you have a little session when something that's appealing to them going on and you break out for 5 minutes and highlight it, that's a good way to catch them. So we're gonna have to tap into their avenues and things that, we know they're the places we normally visit. But it's important because I have had situations where young persons have passed and their families have come to me, no will, but you have assets and no certainty of how the assets were to be distributed. So when you say to them, well, BVI law says this is what's supposed to happen, they're devastated.
Okay, thank you. And that ties into my next question.
I think one of my colleagues was.
No, I just wanted to add that I'm happy to say that I'm starting to see a lot of young people start asking questions about will. But normally it stems from some situation where it is that they've seen, like for me, I've seen young men where their partner have died, they've gotten shot or something, and seeing the fights and stuff that their family goes through. A lot of seeing young ladies where they're single parents and then having situation where they're saying, well, I don't want my child fired, I have to take care of my child in case so-and-so. So it's based on situations, but I'm starting to see it, and they're asking questions.
Okay, thank you. And my last question is, as Ms. Smith said, if you don't have a will in place, like you were just saying again, the law would make the decision. So I wanted to know if it ever have a case or is it ever a case where like the immediate surviving relatives can come to like a common ground without the decision being made by law? Like, yeah.
Depending on who the immediate families are. Because the law says, for example, if you don't have a will, there's a chain in terms of how you inherit. And therefore I'm saying if you, for example, have a cousin, and you may think a cousin is an immediate person, that cousin can't jump in ahead of others to come to common ground. The persons in that chain under the Intestate Estate Act can come to some common ground where they all as beneficiaries agree and consent. But as I said, you have to bear in mind when you say close family members, who you're referring to, because some cannot just jump ahead of others in terms of coming to that common ground in distributing the assets.
Good day. My first question, I have 2.5. My first question is for Ms. Smith, based on what she stated earlier. You stated that there are no limits to the amount of changes that one can do to their will. But can these many changes become subject of the validity of the will, where persons who thought they were beneficiaries question now whether duress was involved?
Well, I would say that only becomes relevant if that person knew how many times the will was changed. Because ordinarily you don't have beneficiaries really knowing that a will is in existence in the first place. So you won't have, when you have the will, the final will, you won't have a pileup of wills then that would disclose that there were many changes. If there is a beneficiary or a person who knows that the will was changed many times and possibly there's not a provision in there that's in their favor any longer, that can, but at the end of the day, the will, if the final will is done and it's properly done in accordance with BVI law, it's going to be difficult to challenge it. But I can see where, yes, somebody who may have been in a previous version and not in the last version will, but yes, but that doesn't automatically make it invalid. It can't make it invalid. The will is already done in accordance with BVI law.
My second question is for Mr. Husbands. Well, for anyone, but I think Mr. Husbands is who spoke about the formalities of the will. So, are there any special preparations in drafting for persons who are like blind and incapacitated in any other way? What should be done in drafting their wills?
Oh yes, well thank you for raising this because I should have mentioned it. If the person is blind or even illiterate, and you don't find many illiterate people these days, the will would have to be read over to the person, and they'll have to indicate that they understand it. And if they can't make the signature, they could make a mark, an X or whatever. But blind people obviously can still sign. But it'll have to be read over to the person. So special precautions should be taken. Those bills should really be done by lawyers rather than at home by relatives, because particular care must be taken to ensure that it is read over properly, the person understands it, or the person may not be proficient in English. They may be from Dominican Republic. So their proficiency may not be good. So you have to make sure that steps are taken to cause them to understand what is in the will. Yeah.
And my final question is, I don't remember who exactly said it, but they said that the beneficiary cannot witness the will. But can a beneficiary help in drafting a will?
The situation, remember, a will generally gets tested after death. The question would be that information, how would it come out that the beneficiary was there? You know, would it be that somebody who also was there challenged was, you know, so because as a testator you don't get a second chance to really correct your error, if it is you've passed, it would be recommended that the beneficiary not partake in drafting the will, because you're certainly opening yourself to scenarios like that, you know, so preferably not.
Yes, it may be said that you impose undue influence on the...
Undue
Yeah.
influence, that's
You
exactly.
influence the person to give the whether your favor.
Thank you.
Good, something, I think it's still morning. Everyone.
Okay, I have 3 questions, I think. The first question is to anyone on the panel. When writing a will, I've had a little bit of experience recently, we don't want to talk about, but advice being given to the author of the will as in how to divide up their assets. We tend to hear a lot, you have 6 children, you divide it equally among the 6 children, but you only have, say, so you have 4 properties, you have, you know, you have different assets, but the will says you divide equally amongst the 6 children. The children are of age where they also write their will, and they do the same thing, where they say whatever they get, they divide equally among their 6 children. And realistically, what happens, the fraction gets smaller and smaller as you go down the generations, which means that you have more and more persons who need to agree, right? Because it's 1 of 6, who need to agree on whatever happens on that inheritance. My question is advice. Would a lawyer advise that that is a wise way of sharing up your assets, or more practical ways, if you have whatever it is, say this is for this person, that is for that person, wholly, without it being tangled up with other persons? That's one question. Anybody can answer.
Let me respond to that question by maybe even siding with you in terms of the word equally, and how, with my practice, that itself has caused problems. because we've had situations where exactly that. The testator said, I give to my children my land equally. However, now it's being subdivided because you're splitting it among 6 children. When you finish subdivided, it's not equal. One parcel might be 3/4 of an acre. One parcel might be half an acre. You know, you have to put in roads and all that type of infrastructure. So it's not equal. So you then try to share it amongst your children, and then it raises a legal issue because one child is saying it should be equal. My father said he's sharing this property. My mother said he's sharing the property equally. So we as drafters in advising need to be able to come up with terms to address that type of situation. You know, not just say equally, but from a drafting point of view, able to address our mind to those kind of situations. So advise on what to put in the will is important. And, you know, for practitioners like many of us here, we are learning as well from experience based on how things are.
Thank you. Mr. Husband, you look like you were ready to say something.
No, not really. I think that a lot of times the problem is the estate is not administered after the death of the testator. So if you have 6 children, you have 4 properties, you could probably divide it fairly equally, or you could sell a property where you can't divide it and split the money or something, but you can do it. And you can do it then when you only have 6. But if it's not done then, and then your child, some of the children die, and then their children, your grandchildren, get involved, then you may have 20 people, which makes it difficult. So that's why you should take care of the probate of the will.
Okay, I have a sub-question based on what you just said. If there's 6 children, 4 properties, and you want to sell it, then all 6 children have to agree that it be sold. Correct?
Well, the executor
The executor makes that
The
decision?
executor can sell it, you can discuss it with the children
Okay.
and take the advice of the children, and you can sell it if it's given to the executor and he holds it on trust to sell it. If the executor only has to deliver it to the children, the executor then has to transfer it to the children and then they make the decision. But if the executor holds it on trust, he can make that decision.
Okay, thank you very much. That was helpful. My second question is, I guess, to Ms. Smith, because you've been talking about it mostly. You keep talking about what the law says when you die intestate, and that there's a certain hierarchy. Could you define what that hierarchy is so people understand how it goes? Especially since the question of next of kin and all of this keeps coming up.
Well,
What is it?
to answer that question, I would say that will take us a long time.
Oh, my
To
goodness.
discuss the hierarchy, but I'll simply say this. We have the Intestate Estate Act. That's a piece of BVI legislation that when somebody dies without a will, the proper term is you say they died intestate. So that act governs how property or any belongings, any asset of a person is distributed when they did not leave a will. All right, so for example, and this is not going down the chain, the act would say what the spouse, if there was a husband or wife, is to get in terms of personal assets, in terms of residuary assets, meaning anything that's not personal asset. It may say the person did not have a husband or a wife. Who's next in line? There are children, this is how it's supposed to be done. If there were no children, this is how it's supposed to be done. So that's how that act is. It basically goes down the line in terms of your survivors to determine who gets your assets. And, you know, it all depends on your circumstances. If you have a husband, then it says what your husband or your wife is entitled to. If you don't, then it says who's next in line, which would be your children, what that child or those children are entitled to. If you don't have children, then it says who's next in line to inherit. So that's why when I say that the law will say what happens to your property if you don't leave a will, that's what I mean.
If you have no children, it goes to your siblings?
Your brothers and sisters.
They're next in line.
I need to let people
Then your
know.
nephew,
You need to let people know. Mind you.
they're your aunts and uncles.
People need to consult their
Their
lawyers
lawyers,
and
yeah.
get a consultation so that you understand the act, because it's a piece of legislation that the lawyer would have to go through with you. It's not a legislation that says 1, 2, 3. It's pretty lengthy, and as I said, it depends on your circumstances. Then the lawyer can pinpoint and say, this is where you fall, and that's what you're entitled to.
Thank
I
you
should
so
mention that although the spouse, the surviving spouse, first in line, that spouse doesn't get, people think the spouse get half or get everything. The spouse only gets a small share. So if you die without making a will, your spouse gets a small share, not a big share.
And if it's a real estate, the spouse gets a life interest at first. So
Not the
it's
full thing.
important for spouses to understand that legislation.
But again, consultation is absolutely necessary, because this will only be relevant depending on how you hold the asset with your spouse.
Yeah.
So there are lots of spouses that hold assets jointly, which means that you have a automatic right of survivorship, meaning, I'm not an estate lawyer, by the way, meaning that if you and your husband own the property that your home is on jointly, if your husband dies, you automatically own it 100%, because you held it together jointly. And if you die, your husband holds it 100% to do with it as he pleases. So when you hold assets jointly, there may not be a need for a will, because when if one of you dies, the other one gets it. Now, I say that, but that's caveated, because if both of you were to die together, then what happens to the asset? So, these are things to be considered, but it really depends on how you hold your assets as well.
Okay, thank you. Okay, 2 short ones, maybe not from the list. If a will is required to be in writing, why should a digital copy be kept?
Why should a digital copy be kept?
Yeah, that's the question.
Oh, okay.
Right, I mentioned having a digital copy because what a digital copy, where it comes in, the digital copy is the same will. I'm just saying the will that you have properly executed, you filed it, and you've made a copy of it. So you have it on your jump drive or something. It's the very same will. Just in the event that hard copy is lost, you're able to print this will off and make an application to the court and saying, look, there's this copy. I have a copy of it. There's a provision where you can make an application to the court for recognition of what's called a lost will, or a copy of a will. So that digital copy comes in handy at that point to say, there was a will, this is a copy of that will, but it has to come off of that original will.
And my last question, the living will that was mentioned. I think, yes. What legal weight does this document have? Can you ignore it?
So in the BVI, we've had this situation. In the BVI, so it's not a document that's enforceable. It's a document that helps guide your caretaker. It's a document that if, say, a husband, has to make a decision for that end of life for the wife, by having that document, that husband is able to say, well, I know this is what she would want. This is her request. So it's one of those decision making. Can you ignore it? I'm aware of persons who have fought hard and say, I can't let mommy go. I can't let mommy go. That kind of situation. But I know it's not a document that's registered anywhere. In other jurisdictions, such as in the States, I've dealt with situations where it's a legal document in many parts of the States. But for us here, as far as I'm aware, it's not a legal document. But it's just a guide.
May I be indulged with one last question?
Yes.
Some wills say, or have said, that this is given to my daughter, right? Property specifically, but it is not to be sold. It's written in the will that this is going to this specific person. However, it is not to be sold. Is that valid, legal? Does it hold any weight in a will?
Those are the wishes of the person. And some people have gone to the extent of when they transfer the property to the beneficiary, they add that as a covenant on the land register or in the transfer document because it's the condition upon which the person got the document, got the property. So yes, it is valid and it can be enforced because they ask, you will, if you see on the land register in the BVI, there's some instances where even living persons say they transfer property to someone and they say it's not to be sold. It can be attached to the property. It can be a covenant, what we call a covenant on the property, yes. And it should be actually because that's the wish of the person making the will.
Thank you.
Now, before you say it, if you as the beneficiary sees that as a burden, now you have the option of not choosing the gift. You could say, well, I don't want this property because now it's a burden on me. So, even though I may leave a gift to you, you have the option to say, I don't want it.
Okay, are there any? We're gonna, one more question? We have a few more questions. But Mr. Husbands, thank you very much for
thank you.
being on the panel with us this
No, it's
morning.
a
We know
pleasure.
that you have
It's a-
another commitment
Yeah,
that you have
thank you. It's a pleasure as always. Thank you very much.
You are
Thank you.
excused. Thank you, Mr. Husbands. Don't forget to get yourself demiked.
Sorry?
You're still hot.
Oh,
So we have two more questions from the floor. Yes.
Good afternoon, everyone. And sorry, I missed a lot of the conversation, but what I've heard so far is really insightful. So I had a couple of quick questions for the benefit of everyone in the audience, really. Where a testate or where a person has foreign assets, because I know that we've spoken a bit about BVI wills and what would happen in relation to BVI assets when someone's based abroad or based here, but where they have foreign assets, could you shed some light on how they should be taking those assets into account alongside their BVI assets when someone is looking to put a will in place? That's my first question.
Well, I know for our practice, when we are dealing with a will and they have other assets, we kind of specify that this will just relates to my BVI assets. And because depending on where the other assets located, I don't know the laws there. I'm not familiar. So I only generally make sure that instructions specify that these only deal with my assets here in the BVI. I don't know how my colleague.
I agree. It's very difficult for you to advise on assets in another jurisdiction, a will on other assets in another jurisdiction, because you don't know the laws affecting that particular asset. So firstly, I would say that it's advisable that the person be given advice to consult a lawyer in the jurisdiction where that asset is held so that they can possibly do a will relating solely to that asset in that particular country. Because as BVI lawyers, we are primarily concerned with the assets within the BVI. We can certainly advise you as to, for example, the law of survivorship. What happens if property is owned jointly? Can you do a will for that, etc.? In other jurisdictions, that law may be different. How do you advise somebody about the law in another country when you're not familiar with it? So it's not advisable to address assets that are in another jurisdiction. You're better off getting a lawyer to prepare a will in that jurisdiction for that asset.
That's really helpful. And staying on that train of thought, the other question I wanted to ask is in relation to where those people do not return to the BVI. So they're resident there, they're not going to be moving back. obviously, as you said, they've consulted a lawyer there, but they will have consulted a lawyer in the BVI in relation to their BVI assets. What comments can you give in relation to how the probate process changes for their application when they die versus someone who was actually living here?
I'm sorry, if under they have left their instructions in the BVI will,
Yeah.
so the executor will just carry out those instructions. If I'm missing something,
You mean it's a probate application?
Yeah, exactly.
Well, in relation to your BVI asset, you will have to obtain grant of probate in the BVI
Of course, of course.
to address that asset.
Yeah.
So I'm trying to understand.
Okay, so I guess my point is more in relation to where they're domiciled, right? So my understanding is that when someone is domiciled outside of the BVI, as much as they may have a BVI will in place, they'll still need to get an affidavit of foreign law because they will have died elsewhere. They wouldn't have died in the BVI. And then that affidavit of foreign law would be submitted as a part of the package, just confirming that the will that they executed is valid in relation to their BVI assets. I think that's
correct. That's correct.
Yeah.
That's correct.
No, I'm understanding you. That is correct.
That's correct. Yes.
So that's for persons who are, as you say, domiciled overseas.
Exactly,
Yes.
exactly. And then, and just to not take up any more time, the other question was if you could just, because you mentioned life interests earlier in relation to intestate estates. I also understand that these concepts, or the concept of a life interest trust, can be quite useful when you're doing planning within your will as well, particularly if you have a situation where you want to have someone benefiting from an asset during their life, but then when they die, they don't get, during their lifetime, they wouldn't have ultimate entitlement to it, maybe just to the income, and then when they die, it passes to the other persons who are named in the will. I just wanted to see how often you actually see that when you're drafting or preparing your wills on a regular basis.
It's not, I wouldn't say very often, but it has been done.
Mm.
I have prepared wills on that basis. So it has been done.
Okay.
Yeah, I'm starting to see it quite common now. People wanting to put in, I call it part of a testamentary trust, set up that. It's starting to quite common now. It's people are asking for more of those.
Yeah. Okay. I don't want to take up any more time. So thank you. No, that's really helpful. Thank you.
I think there's one more question from the audience, and then I have two of my own. Yes, I have two questions, but they're very, very short questions.
Good day again, Rosita Scaliff Thompson. So I'm familiar with most of the legal terminologies, and there's one thing that I wanted to speak about and perhaps ask the panel to further explain for persons who may not know. There's something called an irrevocable trust, all right? So my question starts like this. Let's say my mom left something for myself and my other siblings. So when she passes, that naturally passed to my sister and myself. At that point, of course, I was not married. I hope my husband's not listening to this. Then I got married. My question is, after marriage, I then had children. How would I protect my descendants' in assets in terms of that comes from my parents? Because my wish is to pass it down directly to my children, particularly considering that there wasn't any prenuptial agreement first. Do I have a way of ensuring that the things that my parents passed on to me before I was married or had children continued in terms of legacy to fall within the path of my children instead of my spouse claiming access to it?
Well, first I would say, go right back to basics. You ensure that your wishes are known by a will.
But,
And that will speak to what should happen to your entitlement.
so where does the trust come in? If I set up a trust, put in those things.
Well, if you want to set up a trust, then you set up the trust to ensure that the persons who you want to be the beneficiaries under that trust are the ones who benefit. So it's a matter of you, whichever instrument you prefer to use, just make sure you have something in writing that speaks to your wishes.
Okay, so,
Whether it be via similar trust or whether it be via a will.
so if I did not do a will outlining this, but I set up a trust saying that this is my wishes in terms of whatever assets I have, the trust is going to have more power than the will if there was not a will?
Well, you have, as I said, you have put in writing what your wishes are. So it will be legally enforceable.
Okay.
The caveat to that, I would say, make sure that you consult a lawyer, so the lawyer can review both documents to ensure that you have done it in the correct way.
That was just a joke about my husband, okay?
I think, Mrs. Thompson, I think what you are seeking some clarity on, and I don't know that I understand, or I am clear based on your question. I think your question really is, in the case of intestacy, where there's no will, whether a trust protects your assets for legacy purposes. So no will, whether intestacy laws can interfere with what you have put in the trust.
That's what we said.
Yeah, can it? I don't know the answer.
There are different ways that you can make provisions for your beneficiaries to get what you want to pass on to them, and the trust is one.
Right, so whether you,
And it will be enforceable, but as I've said to her, it all depends, and I'm saying all this with a caveat because I know a lot of times persons come with actual scenarios, all right, but you would want to first have a lawyer review the document where you're benefiting from, all right, to advise you as to the best way that you can then pass on your entitlement in the event of your death. All right, so a trust is a valid enforceable document, and it's a way that you can make provisions, just like a will. I understand Madam Chair's clarification being sought in terms of intestacy, but if you have the proper advice that ensures via trust or otherwise, then you're covered. It's very difficult to advise when you have not actually seen a document upon which you're benefited from. But the will is not the only way that you can make provision for in the event of your passing.
Okay, thank you. Okay, so I have two questions for my two panelists. The first is more seeking clarity for those listening and those in the audience. We have spoken a lot about the preparation of a will, but preparation of a will, as I understand it, doesn't give the executor of the will any entitlement without that executor seeking a grant of probate. Is that how it works?
Well,
Does an application need to be made to empower you to do what the will says? I think this is something that is important for us to just clarify. You can't, my understanding, you can be aware of a will, the person has passed, you get the will, you can't just run off and do what the will says without being empowered to do so through an application to the court. Am I correct?
Primarily, yes. The process is that you should obtain a grant of probate. There are some things that an executor, limited things that an executor can do. But in terms of, for example, the main things, addressing property, accessing bank accounts, you will have to produce what's called a grant of probate. You obtain that from the High Court Registry by going through an entire application process. And you obtain, the final document you obtain is called a grant of probate. And that is like your passport to then begin to carry out the wishes of the will.
Right, so that's the clarification that I wanted to see.
So yes, the will, it doesn't stop with the will. The person passes, you have to obtain this grant, yes.
And so you will need a lawyer to make the application.
Some people do it in person on their own once they are able to familiarize themselves with the requirements. But it's advisable that you do obtain, and this is not a sales pitch, but it's advisable that you do get a lawyer to assist you with the process, because there are different rules under the legislation that covers what should and should not be done.
Okay, thank you very much. And my very final question is in relation to assets that are encumbered. Can you will an asset that is encumbered? Meaning you have a mortgage that you have not paid off for your house. You're paying it off, but it's not done and you keel over and die. Can you make provision in your will for that house, although you still have obligations to pay to the bank?
The simple answer is yes, because you still own it. That's
Right.
it. It's encumbered. The person who is inheriting it just needs to know that if that loan has not been paid off, then you have the obligation to address that as part of this entire process. But yes, because the bank doesn't own your property.
Right.
When they put a charge on it, they have an interest in it until you pay off the loan obligation. But ultimately, you are the owner of the property.
Right, and I just thought it was important to ask that question and get clarity, especially in light of what Ms. Penn asked relating to young people, because a lot of times young people have automobiles, they have cars, they have things that they may not have finished paying the bank for, but it doesn't mean that they don't own these things and whether they can.
It's important because quite often you hear people when they sign off on a charge, they say, oh, the bank owns my property now.
No.
So it is important to clarify.
Thank you very much. Now, that brings us to the end of our session 1. Thank you guys for being here. We are going to run very quickly into session 2 because we've had so many interruptions. We're going to take a very short break just so the microphones and we can have the switching and the addition of the panelists to the panel. 5-minute break, and then we will resume.
5, 4, 3, 2, 1.
Welcome back to the Money Matters 5th Annual Will and Estate Planning Forum. For those of you just joining, I am Kimberly Crabb-Adams, your moderator for this second session. We will dive right in, first by introducing the two new panelists who have joined us, both sitting to my left. We will begin with Miss Rashida Hodge. Miss Hodge is the official receiver of the Virgin Islands and serves as an officer of the court. As the official receiver, she assumes various roles, including that of a court-appointed liquidator, provisional liquidator, supervisor, interim supervisor, administrator, administrative receiver, bankruptcy trustee, and oversees the affairs of companies placed into insolvency or recovery appointments. Next, we have Miss Janelle Archer. Miss Archer is a partner at O'Neill Webster, and she heads the Property and Business Division. Her practice areas include an extensive range of BVI property, business, and estate matters, including property development and financing, business licensing, and related immigration and employment matters, business succession, acquisitions, ownership or disposal of real estate and businesses, wills and probate, corporate and tax restructuring. Now, we are joined once more for this second session by two of our previous panelists, Mr. Abednego and Ms. Smith. The session will follow the same outline as we did this morning. I will ask questions of the panelists. They will have an opportunity to answer those questions. And at the very end of the question and answer segment, we will open the floor for questions from the audience. Now, my first question is for you, Ms. Archer. And my question is, with regards to asset distribution and having a will, are there other methods one can consider to ensure that their assets are distributed according to their wishes?
Good afternoon, everyone. Thank you for your time. So the first thing I wanted to say is that making a will is essentially just one element of estate planning. I think that's important to understand. So there are other things that you're able to do. So making a will or your last will and testament, that dominates the conversation about estate planning. But during your lifetime, there are other things that you can do. For example, I think David or Ms. Smith talked about joint ownership. To clarify that, not because you own property together necessarily means that it's joint ownership that allows for survivorship. Because you can own real estate in two ways. You can own it as joint proprietors or as proprietors in common. So say, for example, you look at a land register and you see somebody has half share. You have two people and each has half share. Then that is proprietors in common, which means that each person is able to dispose of their interest in property through their will. Where you have joint proprietorship, that's where there's an automatic vesting of the entire property in the survivor when one dies. So that's one aspect, joint ownership of property. You can also do a trust. We talked about that briefly earlier. And a trust is essentially an instrument where you designate somebody, one or more persons, as trustee or trustees, and those persons are responsible for administering trust property for the benefit of another person. So that is one way of doing it. You also have certain assets that people don't think about when they're doing their estate planning. For example, insurance. Insurance, the proceeds from insurance do not form part of your estate. They're entirely contractual. So for example, you have life insurance and you have listed beneficiaries. Now, relationships don't last forever. even the ones ordained by God, marriage, it doesn't last forever, there's death. So, you know, some people put life insurance in place or other insurance policies in place and they name beneficiaries, but then there are different events in life that occur and they never update those policies. So you have persons who are benefiting from your estate who you didn't intend for them to benefit because circumstances would have changed and you just never changed your documents or your insurance to reflect that. So life insurance, retirement accounts, all those different things. You have to ensure that you put plans in place and you make the correct assignments in order that the right persons benefit from your estate. So yeah.
Well, thank you. And a follow-on question for you, Miss Archer. As an estate planning attorney, if someone were to come to your office seeking advice, estate planning advice, what would you say are the 5 top checklist items that they should have?
Well, the very first thing is a sort of comprehensive inventory of their assets. Because some people, when they think about estate planning, they think about things that affect them or things that are readily in their mind on a day-to-day basis, the house that they live in, the bank account that they access almost every day. But there are other things that they own. Maybe they would have inherited property from other family members or other assets. So I would say an inventory of your assets, just understand what you own, or if there are any assets that you will become the owner of through inheritance. So just have a list of those. In terms of property, so part and parcel of having an inventory of your assets, when we're dealing with real estate, again, I mentioned earlier, you need to know how you hold real estate in order to understand whether you have the ability to pass the real estate under your will. Again, if it's joint ownership, it does not pass under your will, it automatically goes to the survivor. If you have a distinct interest, like a half share, a third, whatever, then you can pass that under your will. So understanding the nature in which you hold your assets, knowing the extent of your assets, also have a clear idea of who you want to benefit from your property. Most people think about spouse and children only, but there may be other people that, for example, you take care of during your life. So separate and apart from dependent children, you may have elderly parents, or you may have, you know, it may not be a blood relative, but somebody else that relies on you and that you've grown to take care of during their lifetime. So you may want to make provision for them. So think about those persons when you're thinking about, you know, what you want to give. Also, a lot of people think about only assets, things that they're going to give away, but you also have to think about your debts. Somebody mentioned it earlier about willing encumbered property. Now, it is possible for you under your will to set aside a fund where you're able to pay your debts. Because it's very important to understand that when you die, discharging your debts and your liabilities, that's the first task of an executor. You cannot give out the estate and give all the beneficiaries their gift, and you have the bank standing just waiting, trying to figure out what is happening. So you have to, or you should, make provision for your debts as well. So you can set aside a fund where you say, look, I have this mortgage with this particular bank or whatever. If I were to die without paying off the mortgage, then I want this account, monies from this account, to be used for the mortgage. Now, in most cases, you'd have a life insurance as part of your mortgage setup, so that if you were to die, then the proceeds from that insurance would cover the outstanding amount of the loan. But in the event that you're not required to have a life insurance with your mortgage, then you'd want to set aside a fund. And of course, if you have any other personal loan that you may borrow monies from other people, you want to be able to pay that back and set aside a fund without troubling the gift that you would have given to another beneficiary. So it's important to deal with your debts as well. And also to think about people that you trust, because David would have mentioned it, when you make a will, you have to appoint an executor. That person is responsible for administering your estate to ensure that people get what they're supposed to get. So you always think about people that you trust, and not just people that you trust to carry out the wishes in the way that you want your wishes to carry out. Because they have people who have opinions about your life and about your family members, and they may not agree that your daughter should get this house. Your daughter is ungrateful, she shouldn't get all of these different things. So you have to ensure that you choose people who will carry out your wishes. So I think those are the key things to think about when you're starting an estate plan.
Thank you very much. I found those to be very helpful. I wrote them all down. Thank you for that. My next question is for you, Mr. Abednego, and I am going to rephrase it a little from what is written on the paper. The question for you is, it is believed that people choose companies to hold assets as a way of getting away from creating a will, or to make their ownership not readily known, ownership of an asset not readily known to persons on the outside, and also as a way of protecting assets. Could you comment on this, the use of companies for these reasons that I've indicated?
Yes, thank you, Madam Chair. A primary advantage, as many of us know, of having a company is that it provides limited liability for the individual and for the individual assets. It means, therefore, that your personal assets, such as your home, your cars, your bank accounts, are considered to be separate from the business debts and the liabilities of that business. Therefore, if your company faces a lawsuit, the creditors can generally only go after what the company owns and not the personal assets of you, the owner of the company, the director of that company. So as an example, if you're a person who have lots of various assets, such as you may have land, one or more pieces of land, you may have one or two small businesses, whether, let's say, you have a car rental company, you have a small family restaurant, you may have rental apartments, you may have a boat, you're dealing with boat charters. If each one of these entities, each one of these assets open themselves to liability. If you were to say, put each one of them in a company, each one of them would be particularly within itself like a silo, protected. So if a creditor is going after any one of those particular entities, the other 4 or 5 entities are not affected. Your personal assets are not affected. The creditor, even though he or she may can try to go after the other assets, but they are separate and apart. Each one stands alone. So the company of each one of them, the rental car company, the boat charter company, by having its own and being its own entity, protects itself from that. Now, all of these expenses together now, in the BVI, as we know, in companies, so that's an advantage of having company in the BVI. But there also opens yourself to a disadvantage, because as many of you know, forming a company in the BVI can be quite expensive. You know, here we have to deal with, we have registered agents, and each company that you form requires a registered agent. And now, you know, we have to file, under each company there's its own corporate governance that as directors, as owner, you have to follow. So you have to file annual reports, you know, you have to comply with the corporate governance rules, their annual fees payable for all of the above requirements. So as the example that I make reference, if you have 4 or 5 different type of business, even though it is a recommended way to go, for each one, the average cost of maintaining an individual business is between $1,000 and $2,000 annually, and that's just paying the annual fees. So, whereas it is advantageous for someone who are trying to protect themselves by looking to a company, you have your pros and cons that you certainly would have to consider. Also, very important, if it is you are putting your assets in companies, especially if it's your home, you can't say as the owner of a company or as the director of a company, you know, you really can't say that I'm not paying my annual fees next year. I'm not paying, you know, it's expensive, the company isn't doing nothing, it's just what we'll call a holding company. You know, you can't tell yourself or say to your registered agent, forget about it, I'm not paying fees. You know, don't worry, because what happened, that company becomes dissolved. Once your company becomes dissolved, then the property, if all those assets then become property of the Crown. And that is certainly a direction you don't want to go. So, yes, Madam Chair, putting your property, your assets in the form of a company provides great protection because it separates you personally with liabilities, but you also have to understand the cons of owning a company.
Thank you, Mr. Abednego. And I have a question for you at the end relating to that I would like you to comment on. But for now, we will hold that question and we will turn to you, Ms. Hodge. And it feeds very nicely, flows very nicely from what Mr. Abednego just said about assets or companies being dissolved if you don't maintain them. So my question to you is, knowing that there are associated risks if these companies that we have are not kept up to date, we don't pay their fees, what happens to the assets in those companies if the company is no longer in good standing as a result of the person, you know, whether dying, no longer, you know, paying the fees? What happens to the assets of those companies?
Thank you, Madam Chair. The assets of the company will fall bona vacantia. This principle is property that is ownerless, abandoned, or left unclaimed. It applies to those assets. It happens automatically by operation of law. The ownership passes to the Crown. The Crown does not necessarily have to do anything to assert ownership. It passes automatically. However, the principle doesn't apply to trust. When I say trust, I mean where the dissolved company is a trustee for someone else or others. The bona vacantia principle would not apply in that regard. The beneficiaries of that trust would have to make an application to the court for a vesting order. And the Crown would not be opposing this as the principle does not apply. There is also instances in terms of liquidation where if a dissolved company is liquidated, if a dissolved company is a creditor, if a company is a creditor and it has dissolved, any assets that it would have been entitled to would fall bona vacantia. Also, there's in liquidation proceedings as well, where a company is dissolved and any unclaimed assets would also fall bona vacantia. So it is the responsibility, as David said, for the directors and members to maintain their assets, and if dissolution is on the horizon, then they should dispose of their assets prior to dissolution.
Thank you, Ms. Hodge. And to follow up on that, are there corrective actions that can be taken for assets that have fallen bona vacantia? And what is the timeline to those?
Yes, the law allows for the company restoration process, and there are two processes. There's the administrative restoration process, and there's the court-ordered restoration process. The administrative restoration process, upon notice by the registrar, the company has 90 days in which to administratively restore the company by making an application to the registrar. If that time expires, then they would have to make an application to the court, and they have within 5 years in which to do so from the date of dissolution. However, if there are bona vacantia assets involved with the dissolved company would have held, then they would have to make a request to the Crown to restore the company. The Crown would then have 7 days in which to respond, and if they don't receive a response, then consent is assumed to be automatic.
Right, and I think the next question follows from that. Thank you very much. The next question follows from that. If bona vacantia assets that have vested in the Crown, or bona vacantia assets do vest in the Crown, what can the previous owners, the previous shareholders of that company do to recover those assets? Can they do anything? The previous owners of the company, where the company is dissolved, it did have assets, the assets go to the Crown. What do they do to recover? Can they recover the assets that are vested in the Crown?
Yes, there's a number of ways in which this can be done. They can make a request to, well, in addition to restoring the company, of course, they can also request the Crown to disclaim the property. And the Crown would have 3 months in which to do so from receiving that request. Now, this right to disclaim is a discretionary one, and the Crown can decide whether they wish to do so or not. However, in the BVI, the Crown is usually, generally would exercise this right. If the Crown does not exercise this right within 3 months, they would then have to apply to the court to proceed with the disclaim. There is also instances where the Crown would have taken possession and probably disposed of those assets. Then the members of the company can apply through the approved form to recover those assets. And a certain fee would apply in that regard. However, the Crown is restricted by law. If they receive monetary assets, they cannot return monetary assets. There are also other instances, such as where, in relation to wills and estates, where the deceased estate would have fell bona vacantia, then the heirs can make a claim if they establish their entitlement or a right of priority. They would have to submit documentary evidence to this regard. In terms of a dissolved company that is time barred, in terms of that, the shareholders would have to establish their proof of entitlement and so on, and they can, and in terms of a creditor, if they can establish the proof of debt.
Thank you, Ms. Hodge, that is exactly the question I was going to ask, which you've answered. It was my last question about what happens to the ownerless assets. And I think it is very important, and I'm really grateful for your answer, that our listening audience understands that applications have a time limit.
Yes.
You have to make applications within a certain time, and if you don't, then whatever entitlement you had before the company was dissolved is no longer an entitlement that you can say that you still maintain because you're out of time. The law says you're out of time.
And may I add, Madam Chair, that if a dissolved company does become restored,
Yes.
they would have to apply to have those assets returned to them. However, if they don't have a bank account and they wish for the funds to be turned over to a third party, they would be subject to the AML requirements.
As well. Thank you very much, Ms. Hodge. My next question, and I'm going to shift a little. I like looking at my addressees. My next question is for you, Ms. Smith. It's a very tricky question. So the question on the paper says, contrary to what happens in cases of death, with assets being held in a company, what happens to one's assets if they die without having a will? So I think the question really is, where you have assets that are held through a company and you don't have a will, what happens to those assets?
Well, when you're talking about a company, persons own the shares in the company. So you are able to leave a will saying what is to happen to those shares in the company. Of course, all of this is subject to what my colleague, Ms. Hodge, just said in terms of the assets of the company and so forth. What happens in the event that you don't do certain things. But one can make a will that addresses what is to happen to their shares in a company. If they do not leave a will addressing those shares in the company, then it's identical to any other asset. You are therefore leaving that asset to be distributed as if you died intestate without leaving a will. And what I spoke about earlier about the Intestate Estate Act, that will address what becomes of your shareholding in the event that you did not make provision for the document.
And Ms. Smith, just following on from that, in the same way that we explained that a will is not the end of the road, there are still things to be done once the will is made. Could you just explain very briefly, in the case of intestacy, so you've died without a will,
Yes.
again, it's not automatic that the people whom the law says are entitled can just automatically get up and start running around. There are things that need to be done to vest those entitled people with the authority to do certain things. Can you just explain
Yes.
that a little for our listening audience?
That's correct. Someone dies without leaving a will. That person dies intestate. What you're then, and that person has assets, you then have to apply for what you call grant of letters of administration. That is the process you have to go through via the High Court registry to obtain a grant of letters of administration. What I would suggest you first have to do is consult a lawyer to understand who can make that application. It's not anybody that can just walk off the street because you say you're a relative, you can apply. The probate rules provide for the order of priority in terms of who can apply. And there's certain things you have to do if those persons are not around or if you fall lower down and they may have been deceased. So it's a process that I would say, unless you're able to read and understand the rules and so forth, you're advised to, if you know of someone that died intestate or you have a relative that died intestate, That is, without leaving a will, consult a lawyer, because there's a process you have to go through to understand who is entitled to apply and what you have to submit to the High Court Registry to enable you to be the person to obtain that grant. So again, that process is via the High Court, and just for the all persons benefit, many people don't know, just like if you have a will, if you don't have a will, you will see quite often in the newspapers a notice of somebody dying and somebody applying. For both of those processes, you're required to publish in 2 consecutive publications notice of your application. So the process involves things like that. So you must know the process, or else you will never obtain that grant. The registry has to ensure that they go down their checklist and you have complied with all the requirements of the rules to obtain those grants.
Thank you, Ms. Smith. And shifting again to you, Ms. Archer, for our last question before we invite questions from the floor. From our discussions this morning, what would you say from your practice are some of the common mistakes that people have made in, I would say, failing to protect their assets in an estate planning context?
I think the biggest mistake is not having a proper estate plan. Because some people think that, well, I already told my kids what time it is. They already know if I die, this is what is supposed to happen. David would have mentioned, and Jack Husbands would have mentioned at the very beginning, that your will has to be in writing. And there are certain formalities that need to be observed in order that your will is validly executed. So that's the first one. Just orally saying, okay, this is what it is. That does not work. That's the first thing. The second thing is, of course, you can only give under your will what you actually own at the time of your death. A lot of people during their lifetime, they grant powers of attorney to other persons with very wide powers that allow them to sell assets, encumber assets, do whatever they feel like, and not realizing that this third party has power to distribute and to dispose of your assets. So you would have left, say, a car, or even, well, not a car, because that's obvious, but you would have left a piece of land, raw land, in your will to John. And then when you die, it's found out that Tom, who had a power of attorney during your lifetime, would have already sold that land, and you didn't even know, because it's not something that you occupy every single day. So you didn't even realize that this asset has already been disposed of. So that's the second thing, with broad powers of attorney that you fail to revoke or that you don't keep, an eye on. Then the third thing I would say is, a lot of people think about, when they die, I want this physical thing, this land, these monies, these different things to go to different people, but they forget about themselves. Because in most cases, there's a journey to death. You have a long-suffering ailment or something of the sort, so you know you're going to die. But you fail to make preparations for yourself in terms of end-of-life care. And, people making decisions in the event that you become mentally incapacitated. A lot of people don't think about that because it's hard to think about, it's hard to talk about, and you just don't want to face that fact. So I think David or Anthea would have mentioned the living will as well. So it's important to make provision for yourself on your journey to death. And then the last thing I would say is failure to update your will when changes happen in your life. So we think about marriage, we think about children, we think about grandchildren, we think about acquisition of property and all those different events. But like I said, there's also the breakdown of relationships. Where, you would have assigned certain things in, at the time you had trust, or you cared for somebody in a certain way, you had fondness for someone, and you wanted them to benefit from your estate in a certain way. But then the relationship has broken down, and you no longer want them to benefit. For example, in the same way, well, I should say this, marriage revokes a will, but divorce does not. So if you make a will and then you get divorced after, that will is still valid. So if you provide in that will for your spouse, who is no longer your spouse, to benefit from your assets, your spouse will benefit if you don't update your will to remove or to adjust or to limit or to whatever, reduce the entitlement. So that is important. Ensure that you make the changes along the way because your will walks with you through life and it only takes effect upon your death.
Oh, that is really good. Thank you. Thank you very much, Ms. Archer. We've come to the end of our second session, and I am going to invite questions from the floor. Do we have any questions from the floor? Yes, we do.
This question ain't necessarily towards assets within a company, but Ms. Archer, you were stating that it's wise to make sure that you administer someone you trust, I guess, to appoint as an executor. But even if you appoint somebody that you trust, when people die, people change.
Correct. Yeah.
So I wanted to know if it's now a case where not the survivors, like the siblings or something, kicking up a storm based on what the executor telling them that was left in the will, if the executor themselves holding up the will for whatever reason, like how do you go around that, seeing that they are the executor? And I wanted to know if you have like a time period from when the person died and you have this will. Is there a time period for the executor to go and get this grant of
Probate.
probate?
Yeah.
Or is there a time frame in which all the assets within the will should be distributed to the survivors or whatever the case is?
That's a really good question. And I say that because I had it on my paper.
All right. So to answer the first part, now, an executor, the appointment of an executor is supposed to be someone of trust. It's an office of trust. Now, if it is that after you would have died, of course you're gone. So it's your beneficiaries really who would have an issue with the executor not doing what he or she is supposed to do. Now, there's a thing called the executor's year, which means that an executor is really supposed to act with diligence and ensure that he or she obtains the grant of probate within a short period or a reasonable period in order that they can proceed to distribute the estate in accordance with the wishes in the will. Now, if it is that the executor is just dragging his feet, not doing anything, or he is taking actions that are contrary to the provisions of the will, then the beneficiaries can apply to the court to have the executor, well, first, if the executor isn't doing anything, they can apply to the court to have the executor cited to force the executor to apply for the grant of probate. Now, if the executor has already obtained the grant of probate but is acting contrary, then the beneficiaries or somebody else with an interest can apply to the court to have the grant of probate that was issued to the executor revoked so that somebody else could be appointed in place of the rogue executor. Yeah? So there is always a remedy where someone is not doing what they're supposed to do, because ultimately the will should be administered in the way that the testator or that you intended. So yes, there is recourse.
So when you administer another executor, you say that's done through the court? Or?
Yes.
Oh, okay.
Because you can't, what you have to do is to ensure that the powers that were granted to the first executor who is acting contrary, those powers have been revoked. Essentially, the grant of probate has been revoked. So you need to do it in that process. You can't just apply somebody and have two people sort of butting heads. Yeah.
Good day again. The first thing, I'm not quite sure if when this was mentioned, I wasn't here at that point, but there's been mention of your wills seems to be having an expiration date in terms of, oh, sorry, just in case you're here. It's been mentioned more than once since I've been here about updating your will. What makes it expired? Besides, of course, I would guess the normal thing that the person who is the next in line passes away. What makes a will expire that you would have to update it? Like if I did a will, do I have to update it every 2 years, 3 years because it becomes null and void?
No, to be clear, the will does not expire. It doesn't expire. What happens is that there are changes to the benefit. There may be changes to the beneficiaries and changes to the assets that you own. So you make a will today and you have 3 cars, a truck, and a piece of land. And next 2 years, you would have sold the truck. So you don't have the same amount of assets that you had 2 years or 3 years ago. So it makes it necessary to update the will so that you can essentially have the will reflect what you own or have the will reflect the change that has occurred in your life. So the will itself doesn't expire. The update is really to ensure that the will reflects what your current circumstances are at any given point.
That's very interesting and very valid because initially I'm thinking, okay, if something happens with the next person who has succession, I would expect that it has to be updated. But the way that it was brought forward, it seemed that perhaps there was something in terms of an expiration date outside the normal thinking that perhaps a normal person on the street wasn't aware of. No. So I'm glad that that was clarified. Thank you. The second thing is, based on what the young lady said earlier, and I was thinking that the Scatliffe family, we always tend to have a bit of drama. And it's true. One of the things I remember hearing about is there's always executives for all the stuff. But what if the beneficiaries have an issue with the executor in terms of you may have felt that the executor who was quote unquote trusted to carry on the affairs of the person that passed away wasn't exactly acting in the best interest of that person and somehow inflicted a piece of the property. Based on what you're saying, if that was the feeling of those who are benefiting, whether we may have, I'm not saying we, whether we may have any proof to it or not, can we then take some of the actions that are suggested to remove that executor legally?
If you have a disagreement or if you think that someone else should have been appointed, that is not sufficient grounds to remove an executor because your relationship or your view on someone may differ from the person making the will. We all have different relationships in life. So you're having a difference in opinion as to who's the right person for the job. That's not sufficient. It's only if the executor is not acting in accordance with the provisions of the will, then you would have a leg to stand on to sort of challenge and to have the executor removed. But outside of that, your preference and my preference are, two different things, and you don't have a say. It's my assets. I decide who I want to administer it, and you live with it. That's what it is.
Okay, no, so here's another on-the-street question.
Yeah.
Sometimes, for you guys who do this every single day and had to go to different procedures to learn this, it all makes sense to you. But sometimes the normal person on the street, it tends not make certain sense to us because you're thinking, well, okay, Daddy said this, this is his will, this is his wishes, and I don't agree because if based on what I thought I heard you said, it's known as like a living will, but the person has passed, so it's no longer, their requests are no longer, I would think, valid. My thing is, you also talk about, I think it was incumbencies, that if they're, if they are, there's this thing with land that covenants, right? If they are covenants based on the person who originally owned an asset, let's say, that there's nothing that the beneficiaries can actually do. If, however, we used a bit of our law, like perhaps shell companies and trusts, can we then change things around that there is something the beneficiaries can actually do to not uphold that person's wishes?
All right, so I'll take it in parts as I understand it, but you can correct me if I've misunderstood you. The first thing is in relation to the executors. Now, if there is a valid will in place, and if there is suspicion by the beneficiaries that the person who's appointed as executor should not have been, or there was some sort of duress or undue influence that was exercised in that person being appointed. For example, that person kept whispering in my dad's ear, I should be the person in charge of your estate when you die or whatever. You would have to prove that there was undue influence and that your father, we're just saying father for the purposes of this conversation, that the person did not have total freedom in terms of choosing who they wanted to appoint. So what you're doing there is challenging the will itself. So you're not pulling apart the will to say, okay, this gift is valid, but this one isn't valid because she should have gotten a truck instead of the car. You would have to challenge the will itself on the basis that the person making the will did not have the freedom or undue influence was exercised over them. But you can't pick apart different parts of the will that you like and keep these parts and say that those other parts are invalid because they don't align with what you think should happen. So that's the first thing. If you're challenging the will itself, not pieces of the will. The will itself, right. So you'd have to prove that in order to show that, okay, this will is invalid. Lack of testamentary capacity, maybe the person was ill, or maybe too much influence by another person. Now, in relation to, I think your second question was in relation to assets that are, so I wanted to go back just to say one thing, and I didn't answer your question in terms of a time frame. There is an executor's year, but the law does not penalize you for not applying for the grant within the year, the grant of probate. What happens is that if you're not moving fast enough, then like I say, the beneficiaries can cite you to get it done quickly, but there's no penalty per se. Now coming back to your question, the second part, you mentioned something about, like asset, repeat the second part of your question for me.
It was in reference, thanks. It was in reference to what the young lady had mentioned earlier. I think it was actually Ms. Tai. When you spoke about covenants and encumbrances, you know, if it was the wish of the official owner of the property that I'm passing it on to my daughter or my son, but it cannot be sold. Isn't there any way at all that the beneficiary or intended beneficiaries can basically, as you said, contest that because of a situation going backwards to the executor, number one? And of course, in that case, it would be the undue influences. Or the fact that if it was a living will and they've passed on, are they still seen legally as living? So which means is the new persons that are owning these things can decide what to do as the new owners.
Okay, so there are two separate things. The will that we're talking about, the last will and testament, which is the one that takes effect upon your death to distribute your assets. That is one thing. The living will is entirely separate. What the living will does, it allows somebody else to make decisions for you while you're still alive in terms of end-of-life care and decisions for your health. For example, you don't want to be resuscitated. You want to die at home. You don't want to be in the hospital for your last days. That is what the living will is about. It's while you're still alive, somebody else makes decisions because you can't anymore. So that's separate from the actual last will and testament that distributes your assets upon death. Now, in relation to you're giving assets with the covenants or the restrictions, in your will, you can grant a life interest in relation to an asset, and David would have mentioned that, or Anthea, sorry, where you say, I'm giving this property to John for John to use and enjoy during his lifetime. But once he dies, the property is to go to Tom. So that is essentially you're saying, I am not giving John this property outright. I just want him to have the benefit of the property during his lifetime. But he's not owning it. He can't sell it. He can't do any of those. He can just enjoy it. And then you say after he dies, then it goes to whoever. Now, a lot of people would say that they don't want property in their family to be sold at all. It needs to stay in the family. Now, whether or not that is enforceable for years and generations to come, that's a different story. But I always tell people you really can't control from the grave. So apart from doing the 1 or 2 life interests, and then it, it vests with somebody, then I would say that's where the buck stops. But you can try. You can always express your wishes and hope that your family honor them. But it's unlikely that you're able to enforce those sort of long generational standing covenants where you just don't want property to be sold and stay in the family forever.
Any more questions? No. Okay, I had one question because one of them was answered already. And my question is really just to get a bit more discussion around, yes, we understand the importance of a will, and Ms. Smith, you mentioned that wills create certainty, and we absolutely agree with that, but I think it's important to just comment, if you will, on how a will is, in creating a will, it doesn't necessarily insulate an executor from being challenged on that will. And what are some of the common challenges? And this is for any of you, whether Mr. Abednego, you may go first, and then Ms. Smith. Ms. Archer, I know you don't deal with contentious stuff. You are in the safe zone. We on this side of the fence, we deal with the fights. But in your experience, what have you seen in terms of challenges that have been brought and the reasons that these wills are challenged, commonly challenged?
I'll start. And we spoke about it in the first session. One of the challenges we see a lot is when an individual makes multiple will or shares with many persons. So, there may have been a will in 2021. The individual made that will and shared a copy with persons. So one executor may have had a will, and then they made a subsequent will in 2023, and that appoint a separate executor, and that executor has a copy of that will. So these are wills that's being done at home. They're not done in front of lawyers. And then ultimately, when that individual dies, you see several wills pops up. Because as Ms. Smith said earlier, once you apply for probate, it needs to be advertised. So that the person who thinks they have the last will might be a person with a 2019 will, and they are advertising this will. Someone sees it in the newspaper. All of a sudden, you see that there was a 2022 will, a 2023 will, whereas the will that's at the court is a 2019 will. So you then see what's called a caveat being filed to stop that probate. That's one of the common things that I see at times. Person making multiple wills and will done without at a solicitor's office, or the will is not registered at the High Court.
Yes, challenges, even if you have a will, you're open to challenges, the executors. One instance, for example, is where you may have a family member who feel that it was impossible that they didn't get X, or they feel that it was impossible that they were not mentioned in the will at all. So I call that the entitlement syndrome, where they feel that this is my mom, this is my dad, I'm entitled. So they feel something had to go wrong. They don't have a real basis for challenging, but on the basis that they feel they're entitled to something or more, then they come forward. I've seen that.
You also have the instance where a will maker was known to be ill, and it would not have been known possibly, but a will maker may have been suffering from dementia or Alzheimer's, and therefore us lawyers would know that that person may not have had the required mental capacity to make that will, but someone got them to go to a lawyer to do the will. Down the line, you have a family member come forward and say, hey, but my mom has been suffering from dementia for 3 years now. That opens up a challenge, and it has happened in this jurisdiction. All right, so you have those things because, you know, the executor sometimes is innocent in this because I will leave Janelle to be my executor, but Janelle would not have known that David was suffering from, or that I was suffering from dementia or Alzheimer's, and she gets caught up into now having to deal with this challenge. So even though you have a will, there are instances where you definitely will be open to challenges. You have the instance, as I said, where even though it's known that once you marry, if you had a will prior to your marriage, it's no longer valid. But sometimes somebody feel that, my goodness, I'm losing something so good out of that will that they feel, look, I'm going to challenge it. Even though you as lawyers, you explain to them that that's the end of that. So there are different ways. You are open to challenge, and sometimes, honestly, there are valid legal challenges, and from my experience, I've seen where persons really didn't have any valid legal challenge, but just a feeling that something is not right or that I'm entitled to more. And there's nothing the executor can do. They file a court action, and you just have to go through the motion for the court to determine what will be the outcome of this challenge.
Thank you, Ms. Smith. And so I'll just put, I think there's one more question.
I have a question as well.
Well, two questions. And while the mic is being taken, I will say, and this is my plug for those of us sitting on the panel that practice in this area, of the importance of having a lawyer be sort of your intermediary in the preparation and discussions around a will, because this is a professional person, an independent person who I presume if there are issues of challenge of a will and you have a lawyer, can a lawyer be called as a witness?
Certainly.
Yes.
It has happened.
It has happened. So you have this, you know, a lawyer, independent person being able, in instances of challenge, to provide credible evidence as to what happened when the will was being made. And over to you, Mrs. Thompson.
Oh, Mrs. Scatliffe Thompson.
Mrs. Scatliffe Thompson.
Yeah, so thank you. So I'm just thinking about these things as the conversation goes on. They really have no validity. I'm just thinking and throwing these questions up because this is a free forum. Now, okay, so here's another thing. And most of my questions are always going to be marriage related and children through marriages and things like that related because that's my present situation. And I'm going to always use myself as an example so that people can perhaps relate how it is in their lives. All right, so my question is, my husband works, makes money, places it in our joint account. From that joint account, we both have access to it. I then purchase, let's say, for example, this bag, free marketing for H&M, this bag. My husband then goes and creates a will or a trust claiming that this bag is his property and has willed it to someone else or placed it in a trust to someone else with me not knowing. How does the law then deal with something like that? Because as far as I'm concerned, this is my property, but then he will be probably claiming that it was paid with, let's say, his money or joint account money, so he has equal share of this. So how would you deal with something like that when someone creates a document claiming to be the owner of something when as far as you know, the other person is not actually a shared owner of that something. How would you deal with something like that? I hope that was clear.
I think so. I think the question, if I may, I think the question goes back to the earlier discussion about joint assets not being assets which you can put in a will because of the right of survivorship. So if you own, if you have a joint bank account, that joint bank account cannot be the subject of a will, because that joint bank account says that both of these people own the money in this account 100%. So if one of them dies, the other person automatically becomes the owner of this 100%. That's not something you can will. And so while they are alive, now correct me if I'm wrong, panelists, because I am not an estate planner. My understanding is once they die, that is the only time that question arises. And once one of them dies, the other one can do whatever they want with the asset. But while they are alive, they will not be able to make a will distributing or proposing to distribute that asset, because neither of them owns it on themselves, by themselves.
Okay, so which means you cannot even create a will saying that in likeness of my husband and I being married, I've created a will or a trust saying that this half of this is going to be passed on to X person.
Not with a joint, not with a joint asset.
Thank you.
But I think, sorry, one thing though, just to clarify, I think you were also talking about, so he puts money into this account, assuming he alone puts money into this account, but that's irrelevant. The account is in your joint names, right? But you have now extracted some monies from that account and purchased that bag. And you also said he may want to dispose of that bag under his will. So we're not even talking about the monies anymore. We're talking about the conversion of the monies to some asset that you would have bought. Now, that bag and any other chattel, if you will, there is no, like how you have title to land, there is nothing that says Mrs. Scatliff, that's it?
Thomas.
Mrs. Thompson.
Mrs. Scatliff Thompson.
Mrs. Scatliff Thompson is the owner of this bag. So what shows that you're the owner is possession. The fact that you're wearing this bag, you had this bag all along, that is what shows your ownership of the bag. There's no title that says this is Mrs. Thompson's Scatliff's bag. So you would be the one to pass that bag under your will, because we're no longer talking about joint account. That money has been converted to that bag, that particular bag. So it would be for you to pass that under your account. Now, if it is that at that time he jump up and says, no, this is my bag, he would have to prove that it's not your bag. Everybody sees you with the bag, you walk around with the bag, your sister knows you have the bag, you bought the bag, you show it off, whatever. He would have to show that that is not your bag, because there is no actual paper that says.
But here's the thing, what I'm referring to is something even more sinister. I'm thinking, hypothetically of course, that this is mine. And then in my going forward, let's say I'm going to leave it to my cousin. But what I'm saying is that unknown to me, he creates a trust or will saying that he owns it and puts information saying that X bag, he is giving it to such and such. What will have more validity?
It wouldn't matter, because remember, you can only give what you have. So it comes back to the same thing. He would have to show, if he puts that on paper, say that he creates a trust, and he lists the bag as one of the assets of the trust property, or he lists it on the will as one of his assets. At the time of his death, then if you're still alive, you would say, well, no, that's not his bag, that's my bag. It can't pass on to the will because he doesn't own it. You own it. So you'd prove. Exactly. So it'll come back to that essentially. You can only give what you have and what is yours.
And
Thank you,
Ms.
Madam
Hodge,
Chair.
yes.
Let's say someone dies and they were in the process of creating a will and they have a draft will. Can you then take that will and obtain a grants of letter of administration? And my other question would be, are there any wishes outlined in the will that the executor is not necessarily obligated to carry out?
The will or the draft will?
The will.
The will itself. Okay, you're looking at me because I'm the moderator, so I accept you looking at me, but I will not answer because I am not an estate planner.
So long as that will was not properly executed, there's no will.
So that's the first part of her question.
Yeah. And in terms of the those portions of the will that would not be possible, I mean, repeat the question so I can make sure I answer exactly.
So I'm in the process of executing my will. I have a draft will, but I do not actually execute it because I would have passed, God forbid.
No, the second part. David answered
the second
that.
one. Oh,
Yeah.
Are there any wishes outlined in the will that the executor is not necessarily obligated to carry out?
There may be certain things. For example, your will may say that you're to give David $10,000, but you don't have $10,000. It's impossible for the executor to carry that out. So the executor has to basically assess the assets of the estate and see what is possible. I mean, there may be other little things. Some people put funeral requests and so forth in the will, and that may not necessarily be something they can do. Like, for example, one may say, I want to be buried in XYZ country, but, you know, it's not possible via the assets of the estate, or money is not available to do that. So, you know, you really have to look at what comprises the estate and see whether it's possible for, also you cannot give something that the person didn't own. All right, because it has happened. Persons feel, all right, I was the executor of Kimberly's will, so I own the property that's registered in my name as Kimberly's executor. That is not my property. That is property that I, as executor, have to transfer to the beneficiaries. All right, so that's a mistake people make as well. They think because their names go on as owners on property, as executors or as personal representatives, that they own the property, it's their asset. You can't make a will for that property. It's not yours. So there are certain things. And some people may put that in their will, but it's an error to do so.
Thank you.
Okay, this will be the final question, the final question for this afternoon.
Because it kind of sounding to me like only when the person die and then you seeing all what was listed in this will is when you now realizing, oh, he don't have $10,000 for real, so we can't give you. So what I want to know is, because to me that wasting time. So in my mind, I thinking when you're doing a will, you don't have to show proof at the time.
But you see, this wraps into all that we've been saying. You have made that will, we might have made that will 20 years ago, when you did in fact have that money in your account, but you never updated the will. And when you pass, the money is actually no longer there. So that's one instance.
So at the time when they would have that money in the account in 2004, in 2004 when they say they had $10,000, whoever they was doing the will with or whoever registered this will would have had a document to show or a receipt from their bank account to show, yes, they have $10,000 there, or
Well,
no, that's
the thing
not how
is,
it works.
even if the situation is that this will is, the person died 20 years later, even if as a lawyer I saw a bank account with $10,000, I can't make sure that that $10,000 stays there. So, you know, it really goes to show why people should try their best to update their will, you know, so that it reflects, as Janelle said, their current assets.
I think the question, though, Ms. Smith, and I might be wrong, Ms. Penn, but I think what she's actually asking is if at the time of making the will, referring to that $10,000, a lawyer would require proof that that money actually exists at the time.
A lawyer can do so. They can. But it depends on the person that's preparing the will. Some lawyers, and my colleagues can say, some lawyers may not go that far. They will take it from you that you actually have that money. And it's rare that the person is putting that money in their will when they don't have it. What usually happens is that by time it comes to you die, the money has been used otherwise and you just don't have it anymore, or something may have come up. So, I mean, some lawyers can ask for that, but it's not always that they do.
So I don't ask for the money. I do ask for what bank, and try to get the bank details. What I do ask for is land documents, because one of the things I want to make sure is, as we speak here about how the land is held, whether it's land held jointly, it's held in common, and how your name is spelled. Because here, a lot of our names are like a stout would be a stout with one T, and then there's your real name is two T's. You know, so specifics like that I like to ask for. But in terms of the money, no, because remember, the will is a living thing, you know, and so long as you're alive, you can make your changes.
Okay, so that has, we've come to the end of our sessions for today. I actually had a really good time, and I'm leaving with quite a bit of food for thought and quite a bit of insight, because this is not an area that I practice in. Today's session, the aim of it was to underscore for us the importance of planning in our lifetime to protect the things that are most important to us, so that when we die, those whom we leave behind are not scrambling and, you know, left mourning us and also having to deal with the fallout of not having a plan to follow. So, and I think, if I am right, that message has really been made very clear during today's session. I want to thank everyone that came today and asked questions of our panelists. I would love to thank the organizers for putting on this session. It's a very great initiative. I would like to thank those in the audience who asked questions, because I think questions and the answers to those questions oftentimes benefit those listening more than those who've asked the questions. You know, a lot of times we are afraid to ask questions, and, you know, questions are very beneficial to help others to understand what is being discussed and the importance of what is being discussed. I especially want to thank Ms. Penn for some of her questions, especially her interest in the questions around, you know, young people, our younger generation, and, you know, enlightening them. I consider myself to be in that generation. I am not, but I am holding on with my two hands very firmly. But I am grateful to you, Ms. Penn, for asking those questions and, you know, reminding us of the importance of bringing along our younger generation and thinking about things that we can do to engage them. So thank you for that. And our panelists, of course, you know, all of us sitting here are lawyers. Doing things like these require quite a bit of time sacrifice, which we will pay for, no doubt, when we get back to the office. But I am really thankful for you all for taking the time to come and share with us this morning, and now it's afternoon. So thanks so much, everybody, for being a part and joining, and I really had a great time, and I hope you guys did too. Thank you all. Have a good day.
Thank you. Thank you.